Hey everybody, I'm Lloyd Chatfield and this is the Business Law Bootcamp. Today we're going to talk about confidentiality agreements, also known as non-disclosure agreements or NDAs, but first our standard disclaimer. This video is for informational purposes only, does not create an attorney-client relationship, and does not constitute legal advice in any jurisdiction. We would be thrilled to establish an attorney-client relationship with you, but this isn't that. So, confidentiality agreements. Of all the different types of agreements I've drafted and negotiated for my clients over the years, confidentiality agreements are without a doubt one of the most common. My personal opinion is that they are often overused, are often misunderstood, and are not always as innocuous as they seem. If you're in business, you will run into these a lot, and here's what you got to know. First of all, what is a confidentiality agreement? As the name suggests, NDAs are simply agreements to keep information confidential. They arise in many contexts, but the most common are with prospective customers, suppliers, consultants, or other third parties you want to do business with. Oftentimes, in order to decide if there's an opportunity worth pursuing, the parties have to exchange confidential information that is not public. Maybe more than any other common form of contract, NDAs have evolved such that there really is a fairly common template. My law firm buddies will hate me for this, but any good business lawyer can draft an NDA in 15 minutes and can usually review and mark up someone else's NDA form in less than an hour, because virtually all NDAs cover the same basic ground. Number one, what is confidential information? Confidential information is defined broadly in most NDAs. Basically, any non-public information about any aspects of my business is confidential. In NDAs, the real definition actually comes from what is excluded. So what is not confidential information? As a practical matter, NDAs actually define confidential information by what is not included, and there are a handful of universal exclusions. Information that I already know is not your confidential information. Information that is in the public domain is not your confidential information. Information that you disclose to third parties without restriction is not your confidential information. Information that I develop independent of your confidential information is not your confidential information. And information that I learn from a third party without restriction is not your confidential information, and variations on this theme. The bottom line is an NDA without the right exclusions is a recipe for disaster. Another critical question with NDAs is whether they are mutual or unilateral. If only one party is disclosing confidential information, a unilateral agreement will protect that party. If both parties are disclosing information, a mutual NDA will protect and obligate both parties. Parties often default to a mutual NDA because it seems fair, but if the disclosures are truly one way, the NDA should be as well. An NDA should also be very clear about what prohibitions are created. Obviously, the main issue is maintaining confidentiality. You can only disclose the information to members of your team who have a need to know and prevent unauthorized disclosure. But it's also common to restrict how the information can be used. And the general provision is it can only be used for the purpose of evaluating the product, the potential relationship, etc., and no other purpose. Time is also a critical question in an NDA, and there are typically two components. The disclosure period, typically 1 year or less, defines the period over which the parties will exchange information. It's critical to monitor this period, and if you get to the end of the disclosure period but you're still disclosing information, you need to amend the NDA to extend the time. The more critical time element is the confidentiality period, or how long confidentiality lasts. This is typically 1 to 2 years, sometimes as long as 5. Some NDAs will provide that trade secrets, which generally means economically valuable information that is maintained in confidence, will remain confidential in perpetuity, or for as long as they remain trade secrets. Other stuff you typically see in an NDA. 1, there's no obligation to proceed. Just because we're kicking tires does not mean anybody is agreeing to buy the car or even to test drive it. 2, information is as is, where is. I make no warranty or representation that the information is accurate or reliable. Number 3, the legalese. What law applies, what relief is available for a breach, etc., etc. So that's what an NDA is. Now here are some pro tips. Number 1, only use an NDA when you need to. I often suggest the parties have a general discussion without sharing confidential information before they sign an NDA. You might figure out pretty quickly that there's no deal to be had and dispense with the NDA altogether. Number 2, just because you have an NDA Be judicious with what you share. If you're hiring a company to provide third-party logistics, there's probably no reason for them to receive confidential information about how your products are manufactured. Tailor your disclosures to what they actually need. Number 3, assume your NDA won't work. In reality, an NDA is nothing more than a right to sue someone after your information has been leaked. The best protection is dealing with reputable parties and limiting disclosures as much as you can. Number 4, document, document, document. It is critical to track what you disclose and what you receive under an NDA. And number 5, avoid being tainted. You do not want someone disclosing information to you under NDA or otherwise when receiving that information can prohibit activity you are or were planning to pursue. Here's a simple example. A potential distributor agrees to share their customer list under an NDA. You have contingency plans to develop the market independently if you don't move forward with that distributor. That distributor will have an argument that you cannot contact any customer on his list because you received it in confidence. The point here is it's not always advisable to receive confidential information where you might end up precluded from business or activity you otherwise would have pursued. So that's confidentiality agreements. Remember that they're not rocket science, but they also are neither as harmless as they seem nor as effective in protecting your secrets as you might expect. Use them with care. Thanks for watching the Business Law Bootcamp. We'll see you next time.